From the Library of Congress and the Smithsonian National Museum of African American History and Culture.
Today is Monday, July 18, 2011. My name is Joe Mosnier of the Southern Oral History Program at the University of North Carolina at Chapel Hill. I'm in Midtown Manhattan with videographer John Bishop to do an oral history interview for the Civil Rights History Project, which is an undertaking of the Library of Congress and the Smithsonian National Museum of African American History and Culture, and we're just really delighted and honored to be with you today, Professor Jack Greenberg, to talk about some very, very interesting civil rights history and your role in a lot of that history. So thanks for meeting with us. I thought I might start and have you just talk a little bit about how you evaluated the choice to join the Legal Defense Fund as a law school graduate in '49.
Well, implicitly, I really made that choice before '49. I'd started at Columbia Law School with no thought of being a civil rights lawyer because there was no such thing. I thought I would maybe do labor law or things that later would come under the label of civil rights. But I had a professor at the time, Walter Gellhorn, who gave a seminar which he called Legal Survey. And in Legal Survey, students worked for civil liberties, civil rights lawyers. Again, that label really didn't attach to anyone at that time. It was sort of a precursor of clinical legal education. We were working on real cases. And I saw this course listed on the bulletin board, and I immediately ran. I still can recall running up 2 flights of stairs to Professor Gellhorn's office to become enrolled in the course. A curious bit of history that the Smithsonian would be interested in is why he named it Legal Survey. He said if he called it Civil Rights or Civil Liberties, the faculty might not permit him to teach it. Because in those days, if you were a civil libertarian or a civil rights advocate, you ran the risk of being called a communist. And in fact, Professor Gellhorn himself was summoned down to Congress on 2 occasions to swear I am not and never have been a member of the Communist Party. So I took this course, and since the subject matter of the course has changed from week to week, depending on the cases you were working on, I took it for 4 semesters and became chairman of the student body taking that course. After I got out of law school, well, to make a long story very short, I'd worked on some legal defense fund cases, and there weren't a lot of lawyers doing that. Legal defense fund at that time had 3 or 4 other lawyers. The American Civil Liberties Union, which now has hundreds of lawyers, had a single lawyer. There were 3 Jewish organizations that respectively had 3 and 1 lawyers, and that's all there was in the whole U.S., except some individual lawyers who handled some civil rights cases. Anyway, one of the lawyers at the Legal Defense Fund, her name was Marion Perry, was married to a doctor who got some official position with New York State that required him to be in Albany, New York. And so she resigned, and there was an opening. And Thurgood Marshall asked Walter Gellhorn to recommend somebody, and he recommended me. And so that's how I got there. So I had a disposition to do it because I took this seminar for 4 semesters, but I hadn't planned to do it. You could not exactly plan for a career in which there were 6 lawyers in the whole country doing
it. Stop for just a minute. Okay, we're back after a short break. Professor Greenberg, I thought I would extend the theme by asking you to describe that that small band of legal defense fund attorneys, and obviously under Thurgood Marshall's direction there in 49 when you joined. It's, as you say, it's just a couple of folks.
Right. There was Thurgood. Even at that point, but had become a national figure because he'd won the restrictive covenant cases, which I'll describe if you ask me to. He'd won some of the big voting rights cases also. His first assistant was Bob Carter, who was a judge here in New York at the time, he retired. Another fellow called Franklin Williams, who later went on to another position in the NAACP and then became ambassador to Ghana and the head of a foundation, Phelps Stokes Foundation. That was it, and it was me. There was also a woman there who was a full-time sociologist. I'm sure the only law office in the world that had a sociologist on its staff. And that was it. Now, at that time, I might say, we were part of the NAACP. We were a separate and independent part, though the independence caused some tension between Thurgood and Walter White, who was head of the NAACP, but nevertheless independent. And in 1957, for reasons related to tax exemption, we spun off, became entirely independent as the NAACP Legal Defense and Education Fund.
Right.
And that later created some different kinds of tensions.
Yeah. Let me ask, as a young lawyer, you were very quickly in the midst of a lot of very significant litigation in schools, and particularly in schools, obviously in the early 50s. I think you and Bob Carter tried the Kansas schools case out in Topeka.
That's right.
Yeah. Can you share some recollections of that experience?
Oh yeah, well the things you remember about the case are not the important things, because the important things are part of history, so you don't have to mention them again. But the Kansas had a peculiar statute. It was an optional segregation statute. In most of the Deep South, the schools were required to be segregated by law. In Kansas, high schools or high school systems could opt to be segregated, and Kansas had taken that option. We tried the case on two different tracks as we did all the other cases. That is to show that the black schools were not equal to the white schools in what you might call tangible, measurable respects. Number of books, teacher salaries, number of square feet, gymnasiums, playing grounds, curriculum, laboratories, things like that. But then we also tried it on the basis of urging the court, with the help of expert witnesses, to understand that segregation itself constituted an inequality.
Exactly. I know you probably have told this story many times, but let me ask you just to recall your reaction when the Brown decision finally came down in May of '54.
Well, that was a long time from you were talking about the argument, which was in 51, really. And then it was appealed to the Supreme Court in 52, and then argued two more times after that. Everybody was kind of stunned by it. We've won lots of cases before and since, and there were big raucous celebrations. And there was just sort of silence descended on everybody. We were, I think stunned is the only word. It was a cosmic decision. And later turned out to be even more cosmic than we'd understood. We brought a case to challenge school segregation. It turned out the decision swept away all state-imposed segregation.
You were you surprised by the vehemence of the pattern of reaction that arose in the late 50s across the South to early efforts to desegregate schools, or?
That's right, because other cases like that had been won involving higher education, law schools, graduate school, voting, and then in lower courts, things like golf courses, beaches, theaters, and there was sort of grudging acceptance of those. And the cases, those earlier cases, did not involve any mass numbers of people. The higher education cases involved one or two people, but integrating a school system involved large numbers, and more horrible to the segregationists were men and women going to school together, boys and girls. The biggest taboo was any kind of contact between the sexes.
I'm interested to have you talk a little bit about how you measured the landscape of possibility when you became director counsel in '61.
Well, by then a lot of things had happened. '61, the civil rights movement had begun, and students were sitting in North Carolina, as you well know, and elsewhere in the South, and it was picking up like wildfire all over the country. And they were being arrested, and there were no ready defenses for them because it had never been necessary to defend anybody against anything like that. But we understood the constitutional and legal landscape pretty well, and so we were ready with a bunch of defenses. And I might say we ended up, by the time the civil rights movement, well, I don't know what it ever ended, by the time it reached some measurable stopping point, we represented about 3,500 people and got them all acquitted.
I neglected, as we were talking there for a minute about the late 50s, I wanted to ask and have you describe, you published in '59, Race Relations in American Law.
That's right.
Which was an unprecedented volume. Can you talk a little bit about the effort to do that work, to do that volume, and what you were trying to do with it?
Well, a lot of these things, you don't have any ambitions beyond the thing itself because you can't tell what's going to happen. But I was practicing civil rights law, and I was impressed by the fact that there was no book on civil rights law. And I was handling cases in all the areas that the book covered. And essentially I took my knowledge of those cases and put them into the book, which was the first volume on civil rights law since about 1919.
What reaction did the book receive?
It was curious in some ways. It got excellent reviews, but it was considered to be a hot topic. For example, the Columbia Law Review did something I haven't seen them do, or any other law review, before or since. They published a pro and an anti review, as if it were a controversial subject. And then there were some academics who expressed views on civil rights. There was one, Herbert Wexler wrote a famous article called On Neutral Principles of Civil Rights Law. But then there was a legal philosopher at NYU called Edmund Kahn, who wrote a book, essentially an article anyway, attacking the Brown decision for its use of social science data. Anyway, I didn't see how I could have anything against what I'd written, and it would be quite a coup to get him to review the book. So I sent him a copy and asked whether he'd do a review. And he called me and asked me to come to his office. And he said he wanted me to know that he thought the book was an excellent book, but he didn't feel he could review it objectively because his son, he was white, had married a black woman. I said, well, I didn't think that should make any difference. Well, he didn't want to do it.
Fascinating. Can you moving again to the early '60s? You've written and kind of used the phrase that the movement, in some respects, in those after February 1960, really shifted from the courts and into the streets there for many years.
Oh yeah.
And of course, you traveled extensively, had been traveling extensively from New York from the time you joined the LDF. Are there any episodes or memories that really stand out in your mind as exemplary or particularly vivid in recalling those early years of the 60s when the movement was really active in the streets?
Well, part of the traveling was, of course, going on railroads or airplanes, and the railroads were segregated at the beginning. Airplanes weren't, but a good many airport terminals were, even in North Carolina, even though they were federal facilities. So that was something noteworthy. And we brought a number of cases, a fair number of cases, to desegregate airports. And I recall bringing a case, desegregating the airport in Atlanta. Plaintiff, curiously, had the name of Coke, so it was Coke against City of Atlanta, which is the home of Coca-Cola. I brought a case against the airport in New Orleans. My co-counsel was A.P. Turo, who for a period of time was the only black lawyer in New Orleans. Turo, I think it was his granddaughter, I think he was too old for that to have been his daughter, brought his granddaughter to the airport after we won the case. And she ran off just gleefully. She was able to buy an ice cream cone there, something she'd never been able to do before.
You mentioned Attorney Turow, which reminds me of the network of cooperating attorneys that the LDF developed over the years, and pioneering black attorneys in the South who would very courageously take cases in conjunction with Legal Defense Fund. But I also want to ask, in '63, on your own initiative as Director Counsel, you launched a new training program that would become quite a significant mechanism for extending the numbers of black attorneys in the South. And I want to talk about that a little bit.
Well, there were a lot of cities where there was no black lawyer at all, or maybe one, but an amazing number there was none at all. And I got some money from a foundation that if a black lawyer would agree to set up practice in a place where there were no black lawyers, we'd give him $10,000 to buy a typewriter and a rug and some law books. And we got some great stars out of that. There was Julius Chambers in North Carolina, and then one of his law partners later on, who's now the congressman from Charlotte. Noah Watt. And then another congressman, who's in Georgia, what in the world is his name? I'll think of it in a moment, who he didn't want to, he wanted to set up practice in Atlanta, but by then there were a handful of black lawyers in Atlanta. And I urged him to go someplace. He went to Columbus. He was the only black lawyer. And he's now the congressman from Columbus.
Yeah, excuse me. Marion Wright also was in
Marion Wright,
first class. Yeah.
Marion Wright was one of them. Yes, she was terrific.
Yeah. In the run-up towards the Civil Rights Act of '64, particularly say by '63, when Kennedy has introduced legislation, some bill appears increasingly likely to clear the Congress. It's always not perfectly certain, but there's momentum in that direction, particularly after Kennedy's assassination, obviously. And the Legal Defense Fund, under your direction, is really working hard to craft a litigation program that will encompass all of this new legal terrain.
That's right.
And I'd love to have you describe how you were thinking about new opportunities and the scope of what you hoped maybe to be able to do.
Well, one of the things it covered were public accommodations, restaurants, bars, theaters, and so forth. That was pretty easy because the ice cream parlors and the restaurants were happy to get the business. I mean, people would say that the market would take care of it, but the market did not take care of it. Nobody wanted to stick his neck out first. But so we did not have a lot of, no real resistance. There was some efforts of subterfuges. A lot of hotels set up private clubs within the hotel. And I would recall going to a town and being white, checking into the hotel, and being handed a membership card in the club. It just sort of came with being white and registering in the hotel, whereas a black person who registered would never be. Well, that was pretty transparent, so it took a little bit of a while to figure out that's what was going on. The public accommodation, which was Title II, was easy. Title VII was employment, and that, of course, we were opposed not only to employers who may not have wanted to employ blacks, though many of them didn't care, would be just as happy to employ blacks as to employ whites. But we had to confront the fact that the labor unions, which on the national level were very pro-civil rights, on the local level were segregated. And there were white locals and black locals. And the white locals didn't want blacks in, and the black locals often didn't want to lose their members to the white locals. So that was a problem. And we had some of our bitterest cases against the labor union.
Are you feeling comfortable enough with the lights and heat now?
Okay.
Yeah. We're back. We're back after a short break. I'll come back to ask another question or two about Title VII and employment later in the interview, but obviously you were attempting in those years too to find some way forward with schools, and Title VI helped maybe a little bit on that front, but the schools question would remain very difficult through the late 60s.
That's right. A lot of white parents didn't want their kids to go to school with black kids. And it didn't take a lot to stir up enough opposition. So we got an order desegregating the schools. There'd be resistance and it'd be litigated very vigorously. And it not only involved schools, but the real estate values are dependent upon the schools in the neighborhood. So it involved the value of the property people owned. And these cases were vigorously litigated and became the subject of big political fights. And Nixon had what he called the Southern strategy. He was going to be opposed to integration. He had no ideological convictions about this. He just assumed he segregated and non-segregated. He wanted to do what would work for him. After we took a case to the Supreme Court, essentially defeating him and the Congress, won the case. He didn't get in the way, and we had very widespread desegregation. A case called Alexander. I really enjoyed taking that case. It's a great example of how the laws, all legal doctrines are interconnected. We the way the case came up was we had won some cases which indicated that the next round of cases might lead to a Supreme Court decision, or even a Court of Appeal decision, that schools had to be desegregated immediately. And when Nixon, or rather Senator Stennis of Mississippi, after whom a recent aircraft carrier has been named, Stennis saw this was going to happen. He refused to bring the Armed Services Appropriation Bill to the floor of the Senate because he told the president that his people in Mississippi needed him down there to commune with him. And so Nixon had to ask his Secretary of Health, Education, and Welfare to ask the Court of Appeals to send the cases back to the district court without deciding them. And in the district court, then reconsider whether or not they should order immediate desegregation. And that's what happened. His secretary, I think Finch was his name, asked the Court of Appeals through the Justice Department to not decide the cases. Well, at that point, your option to go to the Supreme Court is very limited because the law is that the Supreme Court will hear cases from a final judgment, and the thing that Nixon was asking for was that there be no final judgment. So we had to appeal from the absence of a final judgment, like you said, from a final judgment. Well, there is an ancient common law writ called certiorari. It's not the writ of certiorari that's in the statutes, which the Supreme Court uses to review almost every case it gets. But there's another statute which says that all the writs known as common law are available in the federal courts. And the ancient writ of certiorari, not the statutory certiorari, but or the common law certiorari, said you can bring any case to any court you want. No, it doesn't happen very often. It doesn't happen successfully. So I still recall sort of in what I call mock bravado, telling the staff, my left flank is in disarray, my right flank is under attack, my center collapses. And as Marshal Foch said at the Second Battle of the Marne, I attack. And we did, and the court agreed to hear it and ruled with us.
Yeah. A further high water mark on schools, of course, would be Swan, the Swan Charlotte Schools case in 1971, and I wonder if you can share your recollections of the Swan case and its significance, particularly on busing.
Well, Swan was the first substantive case the court heard on how you desegregate, and Chief Justice Berger wrote a very avant-garde opinion in which he called for quotas and busing and integration of teachers and everything that any civil rights advocate had ever asked for. That was his first opinion after Nixon had appointed him. So Swan, but as the case began in the Supreme Court, it was not at all certain we would win the case, because following the argument, the preliminary vote among the judges was that they would uphold the lower court. They would not enter the order we finally saw. But as the conferences among the judges went on, Berger, who was the leader of a minimal decision, found himself outvoted by the other justices. Earl Warren told me, I still recall the phrase, he said, there he stood naked. And he had, I'm going to turn this thing.
Let's take a brief break. Yeah. We'll come
Sorry,
back.
Jeff.
We're back after a short break. You were just saying that Chief Justice Warren had remarked to you that Chief Justice Berger stood naked.
Yeah, no votes. Well, so he would be a dissenter then. Well, if he's in the dissent, he can't assign the opinion. And he wanted to control the opinion, so he switched his vote and decided to vote as the court went so he could assign the opinion to himself, which is what he did. And he assigned it to himself. But he wrote something in the last paragraph of the opinion which said one of these days this is going to have to come to an end, and they're going to reconsider it and not going to require anybody to do anything. Something of that sort. He couldn't really predict how it was going to come out, but after about 10, 15 years, that's what happened, relying on that last paragraph of Swan.
Yeah. I want to ask, thinking about schools, I know the LDF, I think, was only in one of these two cases, but I'm interested in your thoughts about thinking about how the schools question arced forward from Swan. As you say, it kind of maybe reached a high water in around 1980 or so, and then the numbers shifted back and the court shifted back on the question. But I'm thinking about Milliken in 74 and Rodriguez in 75. The first being the metropolitan consolidation question, obviously, and the second one out of San Antonio being the funding question.
Right.
And I'm interested in your thoughts on those cases and how you gauge their significance.
Well, Milliken was significant in that it made the distinguishing point between city and suburbs, just the political boundary between them. Because obviously you get two families living each like 50 yards on either side of the boundary line. The distance is not very great. Two different political systems, one for one county, one for another, but you can work that out. So obviously the court was making the boundary, the city and the suburbs, having separate different kind of school systems. And that was really a political decision.
Excuse me one sec. We had to break there for a moment. You were talking about Milliken.
So the decision to make